Welcome to Sakshi TV's special immigration show with attorney Ms. Sheela Murthy from the Murthy Law Firm. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST and on Wednesday at 5:30 p.m. EST and on Friday at 6 p.m. EST. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, so today's topic is, we continuing the last week's topic with the H-1B visas. Hello, Ms. Murthy, how are you doing?
Hi, good afternoon to all your viewers in America and good evening to all the viewers in India. I'm doing great. It's the Thanksgiving week and I guess life is going as good as it can in cold weather in India, in the US, and of course in India it's probably nice and warm. So there's always beautiful plus and minuses for everything in life, right?
Right. So, Ms. Murthy, do you have any updates to give our viewers for this week? Any immigration updates in
Oh, yes.
Right.
Yes. So just end of last week, maybe all of you are already aware of it, the USCIS issued a notification for a third registration lottery. This is the first time, of course, that they've been doing this pre-registration. Last year, they did it just once. And then a second time, but this time they've done it once, a second time, and now a third time for people to file, I believe from November 22nd for 90 days. So November, December, January, February till February 22nd. And then in March, the pre-registration is going to start. So it's not a huge number, but based on the number of H-1Bs that they have processed and not been able to fully use up all of the quota numbers, the 65,000 plus the 20,000 master's quota, plus all the people who are exempt because they're working with nonprofits or universities. They now have issued the third registration pickup so that people can now hopefully have another chance to get selected in this year's H-1B lottery. So that's the great and exciting update that just occurred, I think in the last 3 or 4 days just before the weekend started.
Right. So for our viewers, if you need specific consultation, please log on to the Murthy website directly. And when you connect with them, please don't forget to mention Sakshi TV. And from the beginning, the Murthy.com has put a wealth of free information for the benefit of US employers and in the hands of immigrant community. So the Murthy.com site also provides you with latest and cutting edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. So Ms. Murthy, shall we jump right into the topic after the good news that you've given us?
Absolutely. It's a pleasure and honor. Thank you.
Right. So Ms. Murthy, could you tell us what an EAD is? These are FAQs, so we're just talking about the basic ones too.
Okay. So the EAD, of course, is the Employment Authorization Document. It is the document on the basis of which an individual is allowed to work in the United States. Generally, it's issued either with the 485 filing or for the H-4 dependent spouses where the principal has an I-140 immigrant petition approved by the employer. Then the spouse is eligible to apply for the H-4 with the H-4 EAD. And the wonderful, great, exciting news about the EADs in general is that they tend not to be limited to a particular occupation, a job, an employer, etc., similar to an H-1 or an L-1 or an O-1, which allows you only to work for that one particular employer. Here, you're allowed to work for any employer of your choice. And so that's obviously extremely exciting for individuals because they can do any job, whether it's in a for-profit, non-profit, connected with their degree or education or unconnected with their education if they have the EAD card.
Right. So
thank you.
Right. So Ms. Murthy, does an EAD void the H-1B?
In general, the a 485 issued EAD does not void the underlying H-1B petition by its issuance, or for that matter, according to certain prior USCIS policy guidance, even if the person chooses to use the EAD, but also has the underlying H-1B status, the individual can request the employer to file the H-1B extension. And then guess what? The USCIS said that they will cash in the checks, of course, and process the H-1B extension of status as long as that person is still continuing to work with the underlying H-1B employer. So the person will then have, the person and potentially all dependent family members who are of age or either majority or legally allowed to work can use the EAD to work, and the principal can also continue, or the dependents can continue on the H-1B, underlying H-1B, along with the EAD. Thanks.
Right. So, Ms. Murthy, we have a caller on hold, Ms. Swati from Virginia. Thank you for calling. Swati, you may ask Ms. Murthy your question directly.
Hi, ma'am. Good afternoon.
Hi, Swati.
Hi, I have a question, ma'am. Actually, my H4 is approved, but my H4 EAD is still pending. And I raised a couple of expedite requests and nothing is working. So can I raise one more H4 EAD? Can I put another application? Why standalone? Like, because I have my H4 now, can I apply for EAD, another application as a standalone?
Well, but you may be protected. Swati, I don't know, but you would have to see if you are protected under the new change in policy because of the lawsuit, that if a person has the valid H4 extension, the EAD extension is already filed and pending, then the law actually gives you the protection, right? The additional 180 days under the new change based on the recent settlement of that particular lawsuit, where you are protected and eligible to allowed to continue to work by printing out a copy of the new settlement agreement with the USCIS, the copy of the law. And I believe on murthy.com, we have published an article maybe a week or 2 weeks, in the last week or 2 weeks or 3 weeks, as soon as the settlement agreement was finalized, telling you what are the terms and conditions under which you are eligible to continue to keep working legally, even if you do not have the actual EAD in your EAD card in your hand, as was required prior to the settlement agreement based on the lawsuit between the USCIS and certain plaintiffs. Those plaintiffs are protected, but everybody else is protected because it was considered as a class action lawsuit. So either consult with your attorney or feel free, Swati, to schedule a consultation with one of the attorneys at the Murthy law firm that looks at H4 and H4 EADs if you're not clear, because why would you again spend hundreds of dollars and lose several more weeks without any paycheck if you are allowed and legally eligible to take advantage and start working immediately based on having filed the H4 extension and with the H4 EAD and the receipt notice for the EAD.
Yes, ma'am, I understand, but it's been like already 4 months I lost. After expired, I've been like not working for 4 months. And even 180 days is coming only till December 31st. So I have only 1 month now. And I really don't have a hope my H4 is going to approve in 1 month, because I've been waiting for like almost 11 months now. That's why I was wondering, because people who have applied, in August, September, they are getting approvals now. And it's been a year for me and nothing changed in my case. So I was just wondering, should I just ignore the previous one and apply the new application standalone, which is, I think that's going very fast now.
I see. So I don't want to say yes or no. I mean, it sounds like it might be a good idea if you don't mind, spending the extra money again and waiting, because it's less expensive than losing months and months of a job, of a well-paying job. Yes. I can understand why you would want to do it. I don't know that there's any real huge negative or disadvantage by law in doing that. So if you're prepared, Swati, to incur the costs and go through the process and fill it, because you've been hearing of other people who have been filing recently, getting an approval immediately or within a month or two, while you are waiting for 11 months, that could be an alternative strategy to try to get it. And in the worst case, if they approve it and then deny the second one, or approve the second one and deny the first one, that's okay, because you would have already received the EAD card. Good luck.
Yeah, so Yes, ma'am. So, is it legal to have two applications in parallel? Is my original question. Can I apply another one while I was waiting on the first application? So, is that okay to apply the second one, like the second application for EAD?
So there's nothing in the law, Swati, which says it is not permissible or there's some legal prohibition in filing a second EAD application. Technically, the government is supposed to do their darn job after taking so much hard-earned money, so they're supposed to approve it, but there's nothing in the law that says if you file a second one, we'll cancel both or anything. It's not like the H-1B cap subject petitions where if you file two of them, then they cancel both and you get nothing at all. It's not like that. They will take both your checks and they will cash both, and hopefully one of them will get approved, and that way you should be protected. There is absolutely no prohibition as far as I have ever seen or heard with respect to filing a second H4 EAD. So good luck. I hope it works out, Swati. And next time you get an opportunity, if it gets approved fast, that you will call back and share this good news with everybody on Sakshi TV, because a lot of people are listening to each other's questions and answers. All the best.
Right. I do hope that it works out for you, Swati, and you do call us back to give us the good news. So, Ms. Murthy, moving on to our next question. How long does an EB1 green card last?
So I'm not sure what the question is asking, Torini, because the EB1, a green card lasts forever. It's called permanent resident or lawful permanent, and that's for every green card, whether it's EB1 or EB2 or EB3. If the question is asking how long does the EB1 I-140 petition approval remain valid, that also technically an I-140 petition is valid indefinitely, potentially forever. So as long as the person intends to work in that particular job, doing that particular work for that particular, in that particular area of expertise that will prospectively benefit the United States, then you can use that I-140 to file the 485 or to do an immigrant visa consular processing from abroad. So I'm not sure the question is very clear, but I've tried to understand what that question is trying to get at and hopefully have provided guidance to whoever asked you that question.
Right, Ms. Murthy, thank you. So, moving on to the next one. Should one maintain their non-immigrant status after filing for I-485?
So again, we sort of answered this question about H-1B and 485. Does it remain valid? It's usually a good idea to have a backup for most people, but there are always exceptions. In some cases, if there is some kind of fraud or misrepresentation in the underlying H-1B petition, or there's some other possible problem that could create complications, the answer may be no, but in a majority of the cases, it's usually wise to have a backup non-immigrant status like an H1 or an L1, because that way, if the 485 gets denied, you still have protection and a backup status, and you don't have to pack up and leave the country the next day after the 485 is denied.
Right, right. So, Ms. Murthy, we have a caller on hold, a Mr. Shiva from California. Thank you for calling, Shiva. You may ask Ms. Murthy your question directly.
Hi, Ms. Murthy. Thanks for supporting the community. So I have a question regarding my GC processing. So last year I filed my downgrade petition from EB2 to EB3, still in progress. My priority date is March 2012. Now currently EB2 is current, and then I'm planning to do a interfiling in next month. So my company has started new contract with new lawyers, so I wanted to go with new lawyer. So will there be any impact if I interfile with new lawyers, new attorney?
Yeah, it shouldn't matter as long as the new attorney attaches their G28 showing that they are now the new attorney on record for the employer and the employee, then you could absolutely file and just notify the USCIS to please use the previously approved EB2 to interfile it with the pending 485 just to push them along. Now, according to USCIS policy guidance and manual, the USCIS officer is supposed to look at either the EB2 or the EB3 and determine whichever is approved. And we usually prefer to do the interfiling when the priority date, only the final action date is current for you, not if it's just date of filing. Because again, if that changes, then you don't want to waste time doing these multiple applications back and forth. So I would strongly suggest that you confirm, discuss with your lawyer, make sure you're in a good place, that the final action date is current for you, not just the date of filing. And that way, when you interfile, the USCIS can actually approve the I485 with the interfiling request, Shiva. Good luck.
Yeah, thanks. I have another continuation follow-up question. So with the G28 filing, so do they need any approval from the company side, or it's just a one form signing saying, hey, we are good with going with new attorney?
So generally the G28 is sent along with like the interfiling request or some other request, because you want to make sure that the USCIS, if they're going to touch the file, that they're going to include both pieces of information at the same time, Shiva.
Right.
Okay.
I hope that helped you, Shiva. So, Ms. Murthy, we have another caller on hold, Mr. Vishnu from North Carolina. Thank you for calling, Vishnu. You may ask Ms. Murthy your question directly.
Sure, thank you. Hi, Ms. Murthy. Thanks for taking the call. So, my family, I basically have a question on the medical RFE. Is that okay to ask now?
On the RFE for your 485 EAD?
Yes, ma'am. Yes, 485.
Yeah, you can. Sure, you can ask.
Sure.
I know that attorney and Sakshi TV says it's not case-specific advice, and that's true, to protect you and to protect our law firm and to protect the TV station. But people ask for everything connected with their lives, so why not? And I thought it was also a little bit on a lighter note, Vishnu, you called right after Shiva. So first we have Shiva, then we have Vishnu, and next we will have maybe Brahma, Shiva, and Vishnu calling. So I just thought that was funny.
That's perfect.
Go ahead, Vishnu.
Thank you. So, so my family and my medical RFE was raised on 9/6, and so our response basically that included the IN-693 forms and the medical documents was delivered to the Charlotte field office in North Carolina on 9/16. We waited for 60 days for any action to be taken, but we did not see any action to be taken. Basically, like the cases were not updated that the medical is received. So we raised a service request with the USCIS, and we still haven't heard after 10 days after raising the service request. So I was wondering if this is normal, because in the medical RFE it was mentioned that the response should be received before December 6th. But we are getting very close to the timeline, right? But our cases are still not updated. So we were wondering if this is expected, or if we can do anything to expedite or this case here.
Yeah, so Vishnu, it really looks like you have that extra time to send in the RFE request, right? So you have submitted the RFE to the USCIS well before the December 6th deadline. They don't have to open it before on an expedited basis unless they're trying to do it. And you sent it to the local office. So you have to check with the local office in Charlotte, but not with the USCIS Service Center, because the USCIS Service Center does not get involved with local USCIS district offices. So if there's a way for you to go in or take some type of an appointment, or ask or check in or contact the Charlotte office, that might make more sense. And there is no expedite request for a 485 where you've just replied the RFE. They will put it into the file, and they may take 60 days, 90 days, 120 days. They are backed up with thousands of cases that were filed from last October, Vishnu. And I know everybody is so anxious because you've waited so many years and years and years and years to come to this point. So obviously you're getting impatient and you want to get it approved. But with their current staff and personnel and people working remotely. The USCIS is dealing with their own huge problems and staff shortages. So they are not able to process the cases as quickly as all of us want them and expect them and hope that they will process it for us, right?
Right. So
there's really nothing you can do. Yeah.
right. So moving on to our next question, Ms. Murthy, are there any other ways to speed up the processing, green card processing, apart from premium processing? I mean, everybody only talks about premium processing. So is there any other way?
Yeah, there is no premium processing for 485 adjustment of status. There is something separate called an expedite request. So if the employer or the individual explains why an expedite is requested or required in a particular case, then you meet the expedite criteria based on the USCIS website, then hopefully your request could be expedited. But we have seen the USCIS not approving most or majority of the expedite requests because a lot of people ask for it, and unless you can show a direct connection to COVID-19 support, a medical doctor needing to come in, or why they need the approval, we are not finding the USCIS particularly sympathetic or helpful for most expedite requests. So there's something called expedite request if there's no premium processing. There's also, you can contact the CIS ombudsman in some cases. Some people contact the senators and representatives to try to get an answer or to get them to intervene to expedite on a particular case. But other than that, there's absolutely nothing that can be done if you don't follow all of the steps. And the truth is that they're not very sympathetic or helpful because of the huge volume of backlog in cases, and they keep asking for more money for more people, and all the money that is given is being used to hire investigators and fraud detectors instead of focusing on using the same money to hire people who can get the job done for cashing the checks for a service-related organization. Right. So good luck. I hope it works out.
Right. So what if a person is laid off before getting their green card approved while their I485 is still pending?
Yeah, it's fairly common for people to get a layoff or have to deal with it, particularly depending on the time of the year, the economy, the particular industry that's affected, etc. And I know during COVID, we had heard of some cases where there was clearly hiring freezes. Now we have the exact opposite. Everybody in the world is trying to hire people. So layoffs are less common now because of the economy chugging along and being so hot. But let's say it were to happen, then all you need to do, if the 485 was pending for 180 days or longer, is to take advantage of the AC21 adjustment of status portability provisions to show that the new job is same or similar. And if you find another job, which is same or similar job duties, then the new employer would file the new supplement J, confirming the nature of the job duties, describing it, and confirming that it is considered as same or similar, so that the 485 can get approved.
Right, Ms. Murthy.
As long as the 485 was pending 180 days or longer, that's the only catch.
So you just spoke about the AC21 portability. Could you briefly please explain the AC21 portability?
So the AC21 is the American Competitiveness in the 21st Century Act, or AC21 law, as we refer to it. It was passed in October of 2000 by then President Bill Clinton. There are some wonderful provisions that protect people so that you're not stuck being forced to stay with the same employer forever, even after the green card is approved for years and years and years. So as long as a person had filed the I-485, it is pending for 180 days or approximately 6 months. So couple of days, maybe less than 6 months. Then all the employee needs to do is file a supplement J and notify the USCIS of what are the job duties with this particular new employer. And if that is approved, then you're all set to go. You don't have to start a fresh form, a fresh I-140, and file a fresh 485 or do consular processing all over again.
Right. So, Ms. Murthy, when can one take the medical exam?
So a person has a choice of taking the medical exam either before filing the 485, or you can wait until the USCIS issues an RFE, and then you can respond to the RFE, as a lot of people have done, particularly last year, October, because all the medical providers were overwhelmed and refused to and could not provide the medicals before the deadline of filing by October of last year. So you have two choices, either with the 485 filing, which a lot of people tend to do when it's a normal number of cases, or like last year, you can just wait for the RFE and then file it at that time, because the medicals generally are valid only for 12 months. So people say, why should I file it now and then again take another medical or have to update it in the future?
Right. So, Ms. Murthy, we're moving towards the last question for the show tonight. So, what happens, let's say someone has applied for their relative's visa while being a green card holder and then becomes a US citizen later. How does it affect his or her family members, as in the relative?
So it depends on the category, right?
Right.
So for countries like Philippines and Mexico, becoming a citizen actually makes the case 10 times worse, because the backups are much, much more for them, for Filipinos and for Mexicans. But for Indians and most other countries in the world, if you are a lawful permanent resident or green card holder and you file a petition, let's say for your adult unmarried child, then if you want to upgrade it to the adult unmarried child, it moves from the third preference to family-based first preference for adult unmarried child of a US citizen, which usually is a better number and a priority date that is faster. So be careful before you file citizenship if you have filed paperwork to sponsor your relatives, because mostly it is helpful, but sometimes it can come back like a boomerang and become a negative for you and your family members with respect to processing, because it depends on the particular priority date for that particular category of filings. And generally being a US citizen is helpful unless you're a Filipino or Mexican, in which case, and sometimes also I think they've started adding China now, or Vietnam in some cases, it can actually be a negative. So be careful what you're doing and which category you're filing under.
Right. Thank you, Ms. Murthy. With that, we come to the end of the show, and it's time for my favorite part of the show, which is your golden immigration message. So what would you like to tell our viewers this time?
Thank you so much, Thorani. Every time you ask me, I'm taken aback, because I always think, what is different that we can share to inspire, motivate, and excite people? Of course, this week is Thanksgiving. Right. So we always talk about the attitude of gratitude, to be eternally thankful, including for the really bad and negative things that happen in our life, because only if you have a bad day can you compare it to a good day and say, thank you, God, for giving me such a great day today. And if you've had challenges and problems, try to turn lemons into lemonade and say, thank you, God, or thank you, if you don't believe in God, thank you, great, whatever, great being, or thank you for this difficult lesson, because from difficult lessons, we learn the most and the best. Difficult challenges in life make us stronger and better. And so let's be eternally grateful for all the good things that we enjoy and all the bad and difficult things that we have to suffer and endure, because that is what will make us stronger and better. The ability to look at negative and turn it into a positive in our lives. That's my message for this week. And thank you for this opportunity as always.
That was brilliant, Ms. Murthy. And as always, it was a privilege to host you on behalf of Sakshi. We wish you and our viewers a very happy Thanksgiving. Thank you, Ms. Murthy.
Thanks. Bye-bye.
You're watching Sakshi TV Live with me, Torani Makana. Thank you.